Hello, folks. This is Amanda Lawton from Lawton Law & Associates. We are live for our second video of our 4-part series about wills. Last week, we talked about what happens if you don't have a will. This week, we are going to talk about basic information on how to create a will and some questions that come up when you are creating a will. I am just going to take a minute or two while people are jumping on and get everything set up here. Thank you so much to everyone who is joining us for our second week. All right. All right, folks, thank you so much for joining us. Like I said, my name is Amanda Lawton. I am the attorney at Lawton Law & Associates. We are centered in the northeast corner of Connecticut. I am licensed in Connecticut and in Rhode Island. I make lots of house calls, and we can set up appointment times via any online source. We can use the Google Hangouts, we can use conference calls, phone calls. We are pretty flexible here because we are so dedicated to making sure we help as many people as possible. So today is the second video of our 4-part series about wills. Today we will be talking about the basic requirements for writing a will. Last week we talked about what happens if you don't have a will, what can happen to your estate, what can happen if you don't have a living will, what can happen if you don't have a health proxy. This week we're going to be talking about the basic requirements if you do have a will and what happens there. As always, if you have any questions, feel free to comment under this video, or you can always send us an email. My email is amanda@lawtonlawassociates.com. So let's get started. So basic, first thing for having a will in Connecticut is it must be in writing. I remember back when I was in law school, there were some cases where it's not on fancy official paper. It might be written on, some scrap paper that's dealt with on a case-by-case basis, but the bottom line is it must be in video. It must be in writing. The second requirement is there must be 2 witnesses. That gets a little more complicated because there are some requirements for those witnesses. So we will get into that in a couple of minutes. First, I want to get into who can write a will. You must be 18 years or older. That's the first thing. You must be legally an adult. So if you are under 18, your parents can have alternative means for taking care of you in terms of life insurance policies or something else. But if you're only 16 or 17, the state believes that you don't have the mental capacity to give away your estate. So if you are 18 years or older, and you must be of sound mind. So now this comes into play. I personally have seen this be an issue In my own family, it has been an issue with elderly. Before an elderly person writes their will or redoes their will, they must be checked out by a doctor and determined that they are of sound mind. So if you have a diagnosis of something that affects your brain, you absolutely may change your will so long as a doctor deems that you are still of sound mind. So one of the things that I think is important is getting these protections in place in advance. Because as we age, as we get older, as life goes on, you never know what will happen. And you never know when that devastating diagnosis will come about. And so you don't know if you at any point will be deemed not of sound mind. So if you have your will taken care of while you are of sound mind, as long as you are over 18, then in the eyes of the court, you are able to write a will. You are able to give away your estate. You are able to make decisions for yourself and for your future. So those are the two major things about who can write a will. It must be signed by the person writing the will and by two witnesses. The witnesses must sign the will in the testator's presence. So a testator is the person who is writing the will. In legalese, a testator is the person who is writing the will. So I am writing a will. I need to sign the will. I need to have two witnesses that sign the will in front of me. So generally, witnesses must be disinterested. This means that if you are giving away all of your fortunes or your house or your anything to your dear Aunt Sally should not be a witness. In every step of the way, you should always think, what if this was contested? What if something happened and this went to court? What would a judge say? What would someone say who's trying to argue this? And so if you ask yourself that question the whole time you're thinking about these different rules, everything sort of makes sense. So you have to be of sound mind, because what if you weren't of sound mind and someone was taking advantage of you and told you that you should change your will? The court wants to make sure that it really was your decision. What if dear Aunt Sally says, you must leave me all of these things, but don't worry, I will witness it. Well, that's not fair either. So generally speaking, a witness should be a disinterested party. There are some exceptions to that. So let's say that you want to leave $1 million to some organization. You can have a member of the organization be a witness. So it's mainly talking about individuals. So if you have a nephew, or if you have a family member, or even if you have some friend of the family who you want to leave something to, generally speaking, it's not a good idea to have them as a witness. Let's see. Sorry, I have all my notes here. I want to make sure we cover everything. So I did receive a couple of questions over the last week. One of those questions is, what if I write my will and then have kids? So I'm married, I write my will, I plan on leaving things to my spouse, maybe something to some other parties, a friend or a parent, but then I have kids and I haven't rewritten my will. Will the children be excluded? They receive the portion that they would have received if the testator died without a will, unless the money is left to the parent of the omitted child. So let's break that down. Testator is the person writing the will. Intestate is when you pass without a will. So if the parent, if the testator wrote a will and left the children out because they didn't have children when they wrote it, then the children would receive the same portion that they would have received if the parent had died without a will at all, unless money is given to the parent of that child. So that is fine if I had written in my will that all of my money goes to my spouse, we have children, and the children are excluded from the will, then that's fine, because all of the money is going to my spouse, who is my child's parent. Let's say there was a different scenario. Let's say that some more time had passed, and I wrote a will while I was married, and then something happened to my spouse. We either got divorced or he passed away, and we had children after we wrote the will. And so when I wrote the will, left all of my money to my best friend. So in that case, the money that is left in my will does not go to the parent of the children that are omitted. In that case, the children would get the portion that they would have received. So now that's the information that we went over last week. So you can look back at the video that we went over last week. But it reverts back to those rules as if you didn't have a will at all. So let's say we have a will that is written. Does this mean I cannot provide for a child? So this person must be asking if you wrote a will and then you had children, will they be excluded? Then there's a follow-up question that says, does this mean I cannot provide for that child? Let's say we're dealing with an older person and there is an estranged child. Okay, so in this case, I think the person is asking, let's say you had children and you are older. You, as a testator, as the person writing the will, let's say you're in your 60s or 70s, and you have a child that you haven't spoken to in years. For whatever reason, major family fight, it happens. So you had never changed your will. So in this case, if the omission was intentional, it will be honored. So I'm not really sure which question this person is really getting at, but if you have an estranged child situation and you did not put them in the will on purpose, that will be honored. If you have redone the will and you left out a child on purpose, then the court isn't going to force you to include that child. However, if the child was born after the will was written and it's just that you never updated it, the court may take that into account and the court may provide that child with the portion that they should have been given. But there is an interesting point. If you omit a child, but you do provide for them with an insurance policy or some other means, a beneficiary of some other form of money outside of a will. Insurance policies are outside of wills because you have a specific beneficiary that's listed. They're not considered a part of your estate. If you have the child as the beneficiary for that insurance policy, then the court may look at that and say, the child was omitted on purpose because they were not included in this will, and yet they were included as the beneficiary of this other policy. This does bring up another point of redoing your wills. Can you ever redo your will? Absolutely. The answer is absolutely yes. You can either scratch the whole thing or you can add amendments. It is recommended that you do this with an attorney, because if you don't properly get rid of the old will or get rid of old sections, then those can be challenged. So let's say you have 4 children, and in your original will, you provide for all 4 of your children. Then what happens if we have an estranged child situation, and I no longer want to provide for one of those children? So what happens? So if I didn't go to an attorney, I might cross that section off. I might just write a new will and say, I want to provide for these other 3 children. You have lots of options that I've seen people do. The question is, can it be challenged? And so it's really important that when you're making amendments or when you are redoing a will that you go see an attorney, because you really want to make sure that that last will is canceled out. If those are no longer your wishes, you really want to make sure that you've taken the legal steps to cancel out that last will. So if there aren't any other questions, I think for this week we are just about wrapped up. We talked about how a will must be in writing in Connecticut. It must be signed by the person writing the will, and it must be signed by 2 witnesses, generally speaking, disinterested witnesses, and we talked about what that means. The person must be 18 years or older and must be of sound mind, and we talked about what that means. We talked about what does it mean if you redo a will and you leave someone out, what happens. So if there aren't any other questions, then this video for this week has come to an end, and we will start next week with some of the other things that you can do with a will, like a trust, adding on a trust, adding on guardianship. It looks like my paralegal is helping me out and said, what if I lose my will? So I mentioned last week that if you have an attorney that prepares your will for you, then the attorney, generally speaking, keeps a copy. I know I keep a copy of all of the wills that I have written for folks. So if you lose your copy, it does not mean that the will is null and void. It just means that we need to find it. So there have been some circumstances in Connecticut where maybe even the one that the attorney misplaced, you need to find where it went, because it's out there somewhere. So maybe that attorney passed on his practice to someone else, and so you need to contact that attorney. But it does not mean that it's gone. So that's another reason why going to someone that you trust is really important, because if you write your will and you put it in your desk drawer and then maybe you misplace it, it does not mean that it doesn't exist. It's still out there and it's still your wishes that you wrote down. And so if you write another one later, let's say 5-10 years from now, you decide to write another one because you can't find the first one, it doesn't mean that the first one is wrong. Or that it's not valid. So you should definitely go to a professional and make sure that if you have any questions about any previously written wills, or if you have any questions about how to make changes to your will or write a new one, that you definitely ask an attorney those questions. It's definitely one of the benefits of having an attorney take care of your estate planning for you. So, thank you so much, folks. I know this week was a little shorter. We're going to try and break down these videos into more manageable bits of information. So, if there aren't any other questions, I really appreciate everyone joining me on this video, and we will see you next Monday at 4. Thanks. Have a great day.